All right, we're back for part two, and we finished up with incapacitation last time. So let's move on to, let's say, restoration. So, restoration, the basic aspect behind it is you are trying to restore some type of relationship between the offender and the offended. So you have whatever offense that may have been, whether it be that particular person and or business, but let's just keep it on the more personal side of things and say it's an individual, whether it be that individual or that individual's family. The goal of restoration is to restore some type of relationship or maybe not understanding, but um, like I said, I guess the best way to say it is a relationship between that offender and the victims, so that there is an understanding of each side, kind of where they come from, um, and hopefully some growth on the parts of especially the offender, but both people. So that's restoration. Deterrence, pretty self-explanatory, I would think, but you have specific and general deterrence. So specific deterrence is if I'm the offender, is the punishment going to be either severe enough or uh, structured in a way that's actually going to deter me from committing that same crime or even an offense in general? Is that going to keep me from offending again, right? Am I going to reoffend or recidivize? So that's specific to me. General deterrence is more so if I'm the one who violates, commits a crime, am I is the punishment I receive going to cause you or someone else to think twice and basically not commit that crime due to the idea of like, well, I saw what happened to him. I don't want to do that. Or, for example, if you have some place that would be like life in prison as the sentence rather than death penalty, for example, someone might say, well, that's definitely not worth the potential for spending the rest of my life in prison or having to give up all of my property and basically the life that I have. It's not worth that. So that's deterrence. Rehabilitation is pretty straightforward, also, but that can mean things like drugs, sexual. Those are typically the top two. Whether it be drug rehabilitation, uh, sexual predators, sex offenses can go through the idea of rehabilitation. That's debatable about how well that actually works, but it can in some cases. Drug and alcohol rehabilitation is more effective if the individual actually wants to go through with it. So um, those are, like I said, the remaining the remaining three that we didn't cover last video. That's the community protections. So we're going to move on to the offender protection. And basically, these are the procedural protections that you will get into in procedural law. What sort of protections do you have as far as, like I said, Miranda is concerned? When can you invoke the Fifth Amendment? How far can questioning go? Things like that. If you are the person who has been arrested, or the idea of punishment, for example, we have the Eighth Amendment, right? It talks about the undue harm that could be caused by um, severe punishment. So it prohibits that, right? So as it says here in the screen, it ensures proportionate punishment, meaning you cannot come up with punishments that are perpetual, meaning that they never end, um, or something that goes way beyond. So if I steal, let's just say, $3,000 worth of items from some type of location, like a commercial location, I don't think 5 or 10 years in prison is equal to that. I mean, it's far and above what you would get. Um, so that's just an example there of what proportionate punishment should be or is it has to be in order to protect the offender. We want to to try to keep away from that. Some people might say, for example, oh, well, it's not fair to have felons to where they can no longer own firearms after they've been convicted of a felony. Okay, and a lot of people see it as if it was, and a lot of times this is also how it's done too, to where it's not just every single felony. It depends on the state and what it is, but a lot of states are going back to the was it involved with a violent crime, like bank robberies, or if it was a burglary, was it aggravated burglary, which chances are if they had a weapon or something like that, that would be the case. So there's a lot of factors. We'll go into that later in the semester, but that's something to consider when you're talking about the offender protections. So now the really basic things of classification for crimes, I think most of you know or understand these. I'm not going to go into Indiana specific right now, just because not all of you will work in Indiana. Those of you that work in law enforcement may very well work in Illinois or Kentucky, Ohio, Michigan, you name it. We've had students who've gone and worked in Florida, up north. We've had all kinds of places. So that's why I try to keep it common law, but sometimes we do bring in Indiana just for fun. So felony right here basically is a punishable, any crime that is punishable with death or confinement greater than 12 months. And yes, there are states where you can have a felony and be fined, okay? But for right now, and that's usually over 1,000, but that varies all the time, so I'm not going to go into that. But the very, very basic aspect of a felony is that it's punishable by death, all the way up to death, and all the way down to at least 12 months or at least 1 year of confinement, whether it be in prison or jail. And also, like I said, there can be fines with that, but we're going to focus on the incarceration aspect of it. Misdemeanors, punishable by fine or incarceration under 12 months or a year. So I hope that's pretty easy to break down. I'm not going to get in much more depth than that. Okay, let's talk about malum in se, malum prohibitum. Those are just Latin terms. So malum in se just means bad in and of itself. So that just means things like typically the examples that are always brought up are murder, rape. Theft is kind of on the border, like whether it's right or wrong to some people. But nonetheless, malum in se is something that is in and of itself bad, regardless of who you ask. They'll say, is it okay to kill someone? The vast majority of people will say, no, it's not right. Okay. So without the idea of self-defense and all those things. Malum prohibitum is only illegal because there is a statute that prohibits it, whether it's a protection of a person, whether it be protection of property, even businesses, things like that. But it's not if you want to call it, it's not a moral issue. There's something else to it that the state or the people have decided they want to prohibit that particular act or behavior. Not that it's automatically wrong for every culture, every individual, every nation, wherever you're at. So that's the easy way to think about the differences. Like I said, in se is in itself. Prohibitum is simply because it's prohibited, right? So we'll do a real brief history. Trust me, I'm not going to go in depth with it. Plus, if you have me for criminal minds and deviant behavior, we'll talk about this a little greater depth. But some sources of criminal law that we talk about would be Code of Hammurabi, or the 12, some people call them tablets, some people call them tables. The Code of Hammurabi, that was separate. That would have been back in Mesopotamia. First written that we're aware of, fully written pillars with the different laws and punishments written on them so people could see it. 12 tables or tablets were Roman. And like I said, I'm not going to go into great depth about them, except for both of them focus on retribution, which is some form of punishment for that crime, right? And a lot of the stuff on there would be an eye for eye concept. So, excuse me, we get some of those same ideas. Same thing with Mosaic law. We also get some of those same concepts from all of those. And if we move up a little bit in time, we have common law, which occurred about the time that there was the Norman conquest of England. Not going to make it a history class. If I were in person, I'd probably explain it more, but for time purposes, we'll just cut it short and say what happened basically with the conquest of England. What we had was new law, new thoughts, new cultures, whatever. So in these different cities or areas, they would have different judges who would hear cases, hear any type of wrongdoing or issues amongst their people, where they were judges. And what would happen was that information, say if I'm a judge, I hear a case, I write that down, the information I had, my decision, and then that gets circulated amongst the other judges. And so therefore, even though we have multiple people working in different places, we share each other's information, see if we have similar cases going on or similar situations, so we can rule more like one another, in essence, have some form of uniformity, okay? Like I said, uniformity among courts and judges is what it led to, which is, if you go forward in our history, we call it stare decisis, okay? Stare decisis, as you can read there, stand by things decided. It's basically saying, it's almost like looking at court case law and saying, all right, well, based on Terry versus Ohio, or based on Garner versus Tennessee, or you name the case, it's going back, referring to a previous case, previous decision, and basing some of your decision on the reasons that that particular judge made that decision, or the judges, what they had to say. So that's all it really is. We'll get into that, as we go through the semester. We'll talk about that a little bit more, especially when we get in person. If you guys have questions about this stuff, feel free to bring it up. So modern stuff, I'm going to go through here real quick. You guys can read this later. Right now it's federal, state, county, municipalities. So federal government has laws, states have statutes, counties and cities or municipalities have ordinances. So that's where, as law enforcement, we get some of our legal authorities, where we get our understanding of what to do, our sources of how we enforce the law. Model penal code, that's something I'm not going to get into a whole lot. It just basically deals with when they are dealing with how to sentence or how to deal with anybody in the penal system, or the if they're in prison, anything like that. That's where they deal with how do we handle these people, how long would they be sentenced. They wanted to have some type of uniformity, and that came about in 1962. We can go over that. Like I said, it's a lot easier to talk about in person. So those are all things that we can talk about then. But then the big one, which blows my mind, how many people, including politicians, who claim to be attorneys or constitutional attorneys, that don't truly understand, don't know, don't care about the Constitution and Bill of Rights, which separated us from a lot of other countries in so many ways. In fact, there are some countries that have, for example, Argentina copied our, not Bill of Rights, but they copied our Constitution pretty much, in a good way. I mean, they thought it was good enough that they just basically copied what we said. So yeah, that's a whole thing. I think I need to stop here so I can make a video, kind of pick up there, talk a little bit more about that as we go forward. So sorry that it's taking a little bit longer to get through this stuff, but I want to make sure we get a little bit of detail to it. So I'm going to, like I said, take a little break from that, and I will see you for part 3.